All right, good afternoon, everyone. Welcome back to the Judicial Proceedings Committee. Today is Thursday, January 30th, 2025. We are on voting list number 3, and we're going to start off with Senate Bill 7, and we'll just have you, counsel, read it in, and then I know we're going to have to hold this because of the fiscal note.
Senate Bill 7 requires the Department of Transportation to develop and identify and implement a training program that includes a curriculum on the identification and reporting of suspected human trafficking.
All right, so the committee's familiar with this because we've gone through this a couple times, but we can't vote on this yet because there is a fiscal note. We'd like to move on it. I think there are some amendments in the works that may curtail the cost. Is that right, counsel? Can we get it back to Josh?
Yeah. My understanding is there may be amendments to perhaps phase in the training requirement, which might have an impact on the fiscal note.
So we'll have the Committee of Jurisdiction review those and see if can bring it down, and it'll be back. Hopefully we'll be able to vote on this next week. Okay, now we'll move on to Jamie with Senator Watson's bill, Senate Bill 11.
Senate Bill 11 establishes the offense of organized retail theft of property with an aggregate value exceeding $1,500. A violation of this prohibition is a felony punishable by a graduated penalty structure based on the total value of the property involved. The bill also has a provision that multiple thefts committed by the same person in multiple counties under one scheme or continuing course of conduct may be joined and prosecuted in any county in which one of the thefts occurred. Finally, there is a requirement in the bill that if a defendant is convicted of or receives a probation before judgment disposition for theft under the general theft statute, burglary, or robbery, that the court must make a finding of fact based on evidence produced at trial as to whether the crime is organized retail theft. That information becomes part of the court record for the purpose of reporting to the criminal justice information system.
All right, questions from the committee? There are no amendments.
No.
There's a motion for a favorable. Second. It's been seconded. Do we need a roll call? All right. Senate Bill 11 passes unanimously. We'll now move on to Senate Bill 40. Josh.
Senate Bill 40 authorizes a person who tows a vehicle from a parking lot or a police department that takes an abandoned vehicle into custody to send specified notices to the owner electronically through the Motor Vehicle Administration.
Further discussion? Is there a motion? Motion's for a favorable. Isn't it properly seconded? Is everyone okay being recorded in the affirmative? All right. Senate Bill 40 passes unanimously. We'll now move on to Senate Bill 92.
Senate Bill 92 adds the intentional visual surveillance of areas of an individual's residence where they have a reasonable expectation of privacy to the list of acts that they can seek relief for by petitioning for a peace order. It also expands the available relief to include removing or repositioning the device used for visual surveillance within 15 days after the peace order is issued, and also refrain from further visual surveillance. You should all have an amendment and also the interlineated version of the amendment in your packet. All that is doing is simply taking the language that is at the bottom of the second page of the current bill, taking that visual surveillance language and incorporating it into the existing criminal statute for harassment. Harassment is currently something you can already petition for a peace order under this section or under law.
All right. So I know we all kind of thought the fact pattern that brought this bill to us a couple of years fits the definition of harassment, but this is a way to ensure this. So you've got the amendment before you. Is there a motion to move the amendment? It's been seconded. Is everyone okay adopting the amendment? All right, now the bill's before you as amended. Before we move forward with the bill, we got another question, and then I want to ask a council question because I know the House has this bill and they're working on this as well. I don't know if you can disclose what they're doing or if not, but Senator Sidnor, go ahead first, sorry.
I was going to just say for the record, the good way that the way that this was drafted, it was done in I think, a very good way, because it ensures that those who have Ring cameras and the like would not be prosecuted for. So I just wanted to make certain that I said that for the records, because I'll leave it there.
No, I think it's a very clean way to do this. But
I know on the House side, they are working on it. The House, the cross-file of this, they're aware of the direction this committee is going, and they're on board with it for that side if we pass this amendment.
Mr. Chair, question for council. If we move it into the harassment section, A1 would say that you can't conduct this visual surveillance with the intent to harass, alarm, or annoy another. How is that different than, is that a different standard that it would have been had it been in the other section, the way the bill was originally drafted?
So as it was, where it was originally, it just said intentional visual surveillance. This would include that it's intentionally harassing, alarming, or annoying the person. So it is a different standard because the harassment standard already has those baked into it. It wouldn't just be a general intentional surveillance.
Right, so the individual that we saw that kept moving his cameras so that, you know, he could see the young women that were dealing with the animals. I'm just wondering if he were to, I'm not sure how he would get out of it because clearly, I'm just wondering if we're capturing the conduct that we want to capture with this.
I mean, I guess it would, that would be, I guess, more of a call for the judge to determine that, but I would say that under this, there was harassment there was alarm or annoying them. I think the reason, well, the judge didn't say this was harassment originally because there wasn't specific language about visual surveillance, and it didn't fit neatly into the other three visual surveillance provisions already on the record, or on the, in the law. So I think adding this in would make it clear that this is the type of actions that we're meaning under harassment to be included in there.
Great, thank you very much. Thank you, Mr. Chair.
So I would like, following up on very good questions of my colleague, I just want to clarify, the way I'm reading it now, so you have to prove the intent of the person surveilling and prove that they intended to harass, alarm, or annoy. So, in other words, in that particular case, which it makes it easier to understand a statute in a particular case, certainly the parents were alarmed and annoyed, and probably a few other stronger words, and I don't blame them. But now I'm just want to make sure, now the burden is going to be on those parents to prove that their neighbor has this intent. Is that how this is going to work? And then that burden is done by what? Preponderance, or is it clear and convincing beyond a reasonable doubt?
For a peace order, it is preponderance.
Preponderance, that's for peace order. So I'm struggling with this because for me, and I know I don't speak for everybody, but I don't think it's relevant what my neighbor's doing or what he intends, because he also might be off his rocker and have no sense of propriety, but his conduct to me demonstrates, and I'm thinking about whether there's a way to adjust this to just not have his like mens rea or intent, but if the conduct from an objective standpoint, not subjective, is alarming and annoying, something like that. I'm just troubled by this guy constantly moving this camera around, basically following these kids after he's been told multiple times to stop. And we wouldn't be capturing that. Again, I don't know what the discussions are in the House, but do you see what I'm talking about in terms of, I think you're gonna have to prove this guy's intent, which is hard. And maybe behavior that's, objective behavior that's you can witness might arise to it if we added some language. I don't want to complicate it and would love to have the bill pass, and just not sure we would be getting to the issue that brought this matter before us.
I do know the House, they were considering because originally it just said intentional visual surveillance.
Right.
And they were thinking about going into maybe defining what that means, the intent part of it. This does add that intent part, 'cause we're just incorporating to what's already there, but that was what the House was considering.
Senator James, actually, I mean, because like, look, you're absolutely right. We're just talking about this. So for this, there are two levels of intent. One is to surveil, and then the one's with the intent to harass, alarm, or annoy. What if you just removed intentionally the intent piece on the surveillance part? So where the new language is, you could just remove the intent standard there, or requirement there.
I was going in that direction, but the way I was reading it is that, three different things you could do with an or in between, and I thought, okay, great, it's just intentional surveillance. But then, 1 and 2 below A, have this intent to harass, alarm, or annoy, and then after the, reasonable warning. So I didn't follow how you would adjust it to address what are you thinking again?
Well, just because there are two levels of intent baked in with this draft, you could just remove one of them. You're still not going to get over I think you have to keep the intent. I don't want to mess around with the harassment statute as it is.
I don't either.
Yeah,
I don't either.
yeah.
But we're pigeonholing it or
Yeah.
in there. We don't want to lose anything. We don't want to undercut that. But I don't know about, I'm just thinking that's a tough standard. Maybe courts, I don't even know the law. I don't know what common law says about this. Maybe you can look up at objective conduct, and a court can rule without the poor moving party having to get into the guy's head, and he's going, no, I'm not trying to do any of that. But maybe that's how it works. I don't know. Counsel knows that you can show that kind of alarming or harassing or annoying conduct by objective conduct. Is that possible? Whatever counsel would like to take it on. And maybe we don't know right now. So, I'm all for moving this right now, but I am worried that the way we've done this has made the burden pretty darn high for what I think is objectively, on its face, an annoying or harassing conduct. So, and I don't know how the law works because don't know this area.
I would say the courts are well adapted, like understanding what harassment is, but then the reason why we have the bill before us is because, obviously, this wasn't considered to be harassment. So, go ahead.
Always fix it next year.
No, yeah.
I'm going to support this. This is what people want.
If you strike the you intentionally could, the first intentionally, if you just strike that, and that way there's still the intent piece the courts have wrestled with.
Yeah, well,
No, go
and I
ahead,
don't want to
Jamie.
blow up negotiations.
Senator Henson and then Jamie.
Mr. Chair, if I'm understanding it correct, the standard in court would be preponderance of evidence. So we're talking it's more likely than not that the person had that intent. So I think that the bar in terms of peering into their mind and kind of proving the intent, the judge has the ability to make some inferences based on the conduct. And then with the more likely than not standard, it shouldn't be too high of a burden. I mean, if it were beyond a reasonable doubt, you're right. It gets into some forensic psychology of how do you know. But with preponderance, I'm thinking that what we have might be able to meet that burden. my thought.
What is the standard for like, for these
For the
peace orders?
peace order, it is preponderance.
Peace orders preponderance.
Yeah.
Right, although-
Thank you, Mr. Chair.
So I do want to clarify, by putting it in the new language in the existing criminal harassment statute, to get a conviction for harassment with this, it would be a beyond a reasonable doubt standard, I think, just to clarify on that.
Criminal.
This is a criminal statute, it's not.
I just do anything I want to do.
All right, well, we can do this real quick then. So the motion is to strike the first intentionally, so that's, is everyone okay? Everyone's adopting that? Okay. We might, I'm just acting on advice of counsel, I don't know. I mean, so just for clarity, even though there is a definition of visual surveillance in the statute, we might want to just plug it back in to create another subsection here, so to be crystal clear as what the visual surveillance is. And then there may be I want you to explain this in terms of the drafting to avoid confusion. If you see, you guys are on page 3 of this, of the interlineated copy. There's subsection B, like, it says this section does not apply to peaceable activity intended to express a political view or provide information to others. And from a drafting perspective, you were saying there may be another subsection created. Can you explain?
Well, just maybe a new section. You know, in the harassment subtitle, you actually have multiple sections that deal, so even virtual harassment has its own section, although, you know, everything in the subtitle deals with some form of harassment. Just to draw the committee's attention to the existing law, in subsection B, it does have a provision that evidently when the General Assembly created the general harassment statute, wanted to make sure that courts excluded any activity that was a peaceable activity intended to express a political view or provide information to others. Just looking at that, I wanted to draw the committee's attention to it because, you know, in this situation, that probably doesn't seem applicable, but maybe something that a defendant might want to, you know, bring into the argument about why they hadn't violated the harassment statute by placing cameras or doing visual surveillance. It seems like a very kind of odd situation.
So to be
but
clear,
yeah.
you wouldn't be deleting it. That's still part of the harassment
Right.
statute. You're just
Right.
putting a subsection so that it's clear.
A new section, correct? Yeah.
Okay.
Yeah.
I think that makes.
Right. So your new, you'd basically be leaving the existing harassment statute alone. Instead, you'd be creating a 3803.1, and the new prohibition would basically just say a person may not intentionally, a person may not conduct visual surveillance of another in areas of the other's residence where the other has a reasonable expectation of privacy, 1, with the intent to harass, alarm, or annoy the other, 2, after receiving a reasonable warning or request to stop, and just the same language that's here, and 3, without a legal purpose. So you're just sort of creating that new section.
Would the B carve-out apply to the new section?
No, because you would be omitting the B carve-out from the new section.
Understood, but couldn't there be, couldn't there be situations where a news gathering organization was conducting visual surveillance using a camera and want B as protection to their news gathering?
And that's kind of why I bring it to the
Okay.
committee's attention. You know, obviously, if the committee thinks that there's a situation where B would be applicable to, say, a news gathering organization that is nevertheless potentially going to be found to have violated the surveillance aspect of it with the intent requirement, they've received the warning to stop, and they have no legal purpose, then B would be something that you would still want in. Actually, I would just keep it in this section then. But if you don't think that B would be applicable, that, you know, there's a peaceable activity intended to express a political view or provide information to others, that doesn't fit, then, you know, you would want to probably move that into just a new section from a drafting perspective.
What do you think? I mean, we're doing this on the fly, so I don't know if you want to think about it.
But somehow become a newsworthy object. It's frequent that like CNN and all those satellites will come like stake out your house, put cameras on you. That would be for me a sensation of harassment, annoyance to me and my family, but nonetheless it's probably a legitimate First Amendment protected activity. Now, like 3 without legal purpose, they would say, I'm here with a legal purpose, but it might be more comforting to also have this B in. I don't know.
I'm trying to think of a scenario in which, like what political activity would you be doing that would, you know what I mean, that would fall into like a harassment, you know what I mean? Senator Loeb.
Thank you, Mr. Chair. I was just trying to figure that out myself, what possible scenario there could be where they have, you know, where they could jump over the hurdles with the intent to harass after reasonable warning to stop and without a legal purpose. I mean, I absolutely hear you that, you know, cameras on your front lawn would be frustrating, but they're not an intent to harass. Their intent is to gather news, and they do have legal purpose. So, I mean, it's a legitimate question. I'm just trying to, I can't come up with a hypothetical, and this is the committee that can come up with any hypothetical, so.
So to that aspect of it, Senator, just sort of, and it's been a while since I've looked at the cases on this, but my recollection of the case law on the harassment statute is that courts have actually looked at that piece in the context of First Amendment activity, which is what, you know, the committee seems to have zeroed in on as well. That it's a sort of a safeguard that's part of the statute because there is such an intersection between potential claims of harassment and meshing up against protected speech or expression of views. So that has come into play where the courts have said, you know, the statute is constitutional because it has these safeguards, and among them that being one. So that's just a little bit of a background.
As we've been talking, I'm curious, does the current statute, or even the addition of this, where the initial amendment was, would this deal with, would paparazzis fall under, could they be prosecuted? Well, I'm assuming, well, under where we've put it, they could probably be considered providing information to others.
Well, you know, I just based on this, I think
and the only reason I'm asking is because if we do it separately from how it's drafted and we make a 803A, then that activity likely wouldn't be protected.
So, right. So I think the specific circumstance, though, is that the applicability would be to, it's in areas of another's residence. So I take that to mean that it would be actually within the residence that they are filming, or that's the area being surveilled.
Right, so they have these telescopic cameras that are
they're looking through the blinds or the curtains or the gaps in them. Right, you know.
Reasonable expectation of privacy, though. Just in your, I mean, the areas of your residence with an expectation of privacy. I mean, I guess.
No, if you don't want anyone doing that, I think the 803.A makes sense. That's all I was trying to distinguish.
No, yeah. Senator Charles.
Senator Sidnor brought up a good point, made me question about paparazzi. You know, if somebody is behind your, at your house, the same way this individual was, let's just say, Senator Sidnor, we know he's a very popular guy and everybody loves him across your district. So this guy puts a camera behind your house and is now looking at your daughters every day. Is that considered paparazzi? I'm more trying.
I was saying that they're not trying to provide information to others.
But they're trying to get pictures to sell and information to sell. That's how they make money.
So would this protect them in that manner?
No, this would, if you adopt this proposed change, it would not protect them in that
Okay.
respect. But,
I'm all for not protecting them on that.
but that doesn't mean that it's not protected First Amendment speech or, I don't know, activity. Go ahead, Sarah Love.
Thank you, Mr. Chair. Just to throw another question in here, the original, the bill as it came in said of areas of the petitioner's residence, and this says in areas of the other's residence. And I'm curious as to the change and whether that would still cover, if you have a backyard that's fenced in and your kids are out there playing.
I interpret just my reading of the language here. Let's say something newsworthy happens that you could imagine public figures, celebrities. I'm not seeing.
Now, I don't know if is that existing language? I think it is, or is that new language that came in with the bill?
Right, and that is applicable to, so that's applicable to the peace order statute.
Well, I mean, are we going to have different I would think that's
Yeah,
a controlling definition of residence, unless you're telling me in the harassment statute or elsewhere, residence is defined differently.
I think that's potentially going to create a problem for the courts in interpreting it. Obviously, would become part of the bill draft, or it's part of the original bill draft. You're not putting that into the criminal prohibition, though.
Right. Well,
I could almost imagine, I could imagine a couple of scenarios. One, a court finding that because the General Assembly included that language somewhere in the bill, they intended that to include a residence. I could also imagine another scenario where a court says, but they didn't include it in the criminal statute, which is where when they do that sort of thing and they want us to know what they mean, they would put it right in that section because it says, in this section or in the subtitle. And clearly we're putting new language in a different part of the code that's nowhere near that subtitle.
and I don't know if residence is defined elsewhere throughout the annotated code for different purposes.
And that's why I think earlier when I was asked the question about residence, I gave the answer that I did, which would be when the General Assembly doesn't define something, typically you default to whatever the common usage of it is.
Right.
I think in common usage, a residence would be, and you're also saying in,
Yeah. Good point.
would be inside of the actual dwelling.
Yeah,
That's why the
good point.
of in is actually important. This is of the other's residence.
Areas of the other's residence.
It says, yeah.
In areas of the other's residence. Well, the other has a reasonable expectation of privacy. And it's both are there. I mean that, I read that to say of, like,
Of the house.
of the house, not in the house.
Well, you may actually have.
Of the residence, not the in.
You know, you may actually want to include a provision that does provide some construction to say that it's not intended to infringe on their protected First Amendment activity.
Which, in that case, you just keep it as it is. Instead of
Right,
that.
right.
So, look, I mean, I think this reads of a residence, not inside. I think that's what it means when that's the way I read it. In areas of the.
I disagree.
Okay.
But no, it's fine.
I read it, I mean, look, that's clearly the intent, it's not in, it's to be of. Otherwise, it wouldn't cover the scenario we're trying to address.
My recommendation would be then for the committee to clarify that language.
Okay.
Just so that there's no doubt for the court.
Okay, so look, how about this? I think residents, we should not port another, or even replicate a definition. I think at the default, whatever the dictionary term is, if they're not gonna cross-reference wherever it is in the code, I think we do need to look at, the definition of visual surveillance, maybe porting that into a subsection, okay? And then we can continue to noodle on, whether you want to add in subsection B for the protected activity. I think maybe you leave it. I've gone back and forth on this now, but I think maybe you leave it, but, so there are at least 3 or 4 points we need to kind of just get 3 or 4 people to sit down and figure out, but I think we're close. Senator McKay.
Mr. Chair, while I definitely enjoy this parlay,
You're the only one.
but this bill was brought for a specific.
Yeah.
We thought it was taken care of. The understanding of the judge was that it didn't. And so by adding what we've added, takes care of this particular issue the way we have passed the amendment so far.
Yeah.
I just don't understand why we just don't go ahead unless there is some form of legal jeopardy that we are creating that's going to cascade to take care of this issue for the intent of what this bill was about.
I think the reason is because if residence only means the 4 walls, then we actually are not capturing the behavior that was the subject.
That's right.
Of the hearing.
So
I'm with you, I want to
I'm
move
with
it
you too,
forward.
But I'm not,
But the hearing related to a backyard and a side yard, if residence means a more restrictive definition, then what we've done has not actually included the wrongful behavior that was testified to.
Can I give you the language that I think would? So,
here we go.
Now, I think if you're under 18, we should have language in there that yard, building, I don't think you should be surveilling anyone under the age of 18. That's, right, I just can't believe that's okay
Yeah.
for us to be doing. I don't think there's a First Amendment right to surveil.
Children or minors.
So-
And
That would help.
Bill's original intent, because we're not going to be protecting those children.
So to address that specific scenario,
Let's get news real quick and then Jim, go.
So you can't just say residence and yard or property of?
yeah, so I think I was about to just give the language that I would use to address
Okay,
this
okay.
situation. I would say conduct visual surveillance of another within Conduct visual surveillance of another's,
Residents.
of or within another's
Can't use
residence.
within. You can't do within.
Well,
Within, that seems more ambiguous.
then,
Just of another's.
hold on. Yeah.
Senator Luff, go ahead.
I do believe I've fallen down the JPR rabbit hole. So I'm thinking about First Amendment issues, and you're wanting to include B in there. And I agree that we've got to make sure that we are protecting First Amendment activities. My concern about this particular phraseology is intended to express a political view. So what if this guy just puts a candidate sign right above the camera? Does that then inoculate him from this? So can we put a little bit broader of language that would just say, this section does not apply to purely First Amendment protected activities?
Right. So there is some language in the code that we use in other places where this has come up, and there's been a concern about protected speech. I don't have it at my fingertips right now, but we could pull that up for the committee and get that for you guys.
Yeah, I think that's
it's more
a great
general.
idea.
It would be nothing in this section may be construed in a manner that infringes or abridges a person's First Amendment rights guaranteed. Yeah.
Yeah,
All right,
thank you.
so here, let's just do this. We've done a lot of good work now, so I want to adopt those amendments, and then we're going to bring this back.
Okay.
Unless you think you can find that other First Amendment language, but let's go ahead and reread the definition of or in, so the residence.
Right.
Okay, let's.
Like where?
Yeah, let's do that, and then see if the committee wants to adopt that.
So page 3, underline 20, in the new language, or in the new language being added to 3803, which is the harassment statute, would now read, would strike the word intentionally and strike beginning with another, all the way through to others. So now it would read, a person may not follow another in or about in a public place, comma, conduct visual surveillance of another's residence, where the other has another's residence in areas where the other has a reasonable expectation of privacy. Comma, or maliciously engage in a course of conduct that alarms or seriously annoys.
Okay, so can we adopt that? We haven't even gotten to the definition of visual surveillance. The second question, are we going to port in a definition of residence? Do you want to do that? So the definition under the Courts and Judicial Proceedings article is on page 1 to the top of page 2. That's the definition. Do you want to port that in under this section for more concrete guidance? John or Jamie, what do you all suggest?
I think for clarity, if it's your are going to read what appears in the code book, not the act, that you should add that definition.
Is everyone okay doing that? Okay.
And that's in like,
That's amendment number 3, right?
we're like on amendment number 4.
Amendment number 4, okay, got it.
But where exactly?
So
Where are we putting?
the specific amendment, Sandy, would be that we're going to plug that into subsection A of 3803. And for the record, the definition will be of the word residence, and it will state residence includes the yard, grounds, outbuildings, and common areas surrounding the residence.
Senator McKay.
So if you would just attach after residence, just add and/or curtilage, that would cover all that.
That creates.
In common law, curtilage is known as of a house or dwelling is the land immediately surrounding it and includes closely associated buildings and structures.
I think it's a good point, but I think okay.
Yeah, I think this may provide a more. I agree with you that that curtilage would be included within those things, or many of these things would be considered curtilage. This may be a more specific guidepost for the courts as far as looking at what areas are covered in the meaning of the word residence.
Do you feel the same way? John?
Agree with what Jamie said. I think taking this definition over, one, it's consistent, and it's also consistent with what the bill was originally doing. That was the definition it was originally using. So we're making sure that is carried over in this new part of the code we're putting in.
So the last piece then, well, 2 more pieces left. Can you guys wordsmith right now the constitutional protections? I mean, is there something, can you port that, can you find it in the code? Well, let's scratch that for now. Let's go to, so counsel's advised we should probably replicate the definition of visual surveillance. And under the code, go ahead and Jamie, can you read it out for us?
So just as an example in the code, 3901 of the criminal law article, which does pertain to certain types of visual surveillance, provides that visual surveillance is defined as surveillance by direct sight, the use of mirrors, the use of cameras, or the use of an electronic device that can be used surreptitiously to observe an individual.
So then you would create another, where would that subsection go? Would it?
It would also be part of subsection A, and it would just port that language in.
Got it.
Yeah.
Is everyone okay doing that? Yep. Okay. So that's amendment number 5?
I don't know.
Okay.
Because we did,
Okay.
we adopted one and then we
Okay.
adopted it again.
Senator McKay, Senator McKay, real quick, do you have the same question?
The same question.
So, counsel, if we look at page 1, line 23, it's already defined that residence includes the yards, grounds, outbuilding, and common area.
Yes. We just took that definition, put it into this section, make sure that it was clear.
Okay, but it's already there.
That's in,
Received article, not the criminal law article. So putting in the criminal law article. The next section.
Okay.
Well, just because. No. Just for criminal law, the more specific you can get, the better. Just because it's in a different article, but it's the same definition. So we've done that. Now the constitutional language is the last piece.
And this may be something, I can try saying something on the record here and you guys can adopt it, or you could just vote to adopt it in concept and just say, come up with language based on what's in the code.
Because, because here, no, I mean, this is actually important. So I'm.
For language, my best attempt at that would be, this section may not be construed in a manner that infringes on on an individual's right to free speech, because there's also the right of the press. An individual's rights under the First Amendment of the United States Constitution or the Maryland Declaration of Rights.
Okay.
So just leaving it at their First Amendment rights and the corresponding rights under the Maryland Declaration of Rights.
All right, so look, can you also, let's also get just the other language that's already in the code. I know what we're doing, but like, if you could just get, someone could help find that, that'd be great. But
Oh, the existing law?
yeah.
Yeah, 10308. A little bit more comprehensive. So 10308 of the criminal law article is an example. Nothing in the subtitle may be construed to infringe on the speech of a religious leader or other individual during peaceable activity intended to express the leader's or individual's religious beliefs or convictions. That doesn't exactly fit. So nothing in this section may be construed to infringe on rights guaranteed under the U.S. Constitution or Maryland Declaration of Rights.
There you go, that's it. That's good. Okay. All right. Right. Can you read it one more time and write it down?
Nothing in this section may be construed in a manner that infringes on rights guaranteed under the U.S. Constitution or the Maryland Declaration of Rights.
That's right.
Great.
Okay.
I mean, outside of the media, is visual surveillance a protected action under the First Amendment? I mean, I know if you're talking about visual surveillance by the government, now you're implicating the Fourth Amendment. So it's prohibited because it could inhibit freedom of speech. I'm trying to. Do we have to do this right now? I mean, instead of putting them, I mean, can we go back? And,
We're gonna do something with it.
You could just say silent on it. I mean, don't just keep.
Yeah.
All right. So we've got the amendments adopted. The bill is before you, remember, we're going to hold the bill for one last work session. I think we're very, very, very close. The last question was whether we do the, oh, you want to add them in?
No, I'm just saying, we're close. Until we add in them part of the discussion the next time.
That is very
Oh,
true.
Chris, oh, I'm just, probably all the files there are all about this.
All right. Well, we got some really good work done, all right? Look,
I just think that Sandy needs to work in the margin there.
all right, well, we're going to hold the bill, but we've done some good work. So the interlineated copy will be before you with the adopted amendments that we've done today. Sweet. All right. That was a good exercise. That was fun. All right. All right. That was pretty good. That was good. Fun too. Oh, man. All right. Senate Bill. There's no other place I'd rather be on a Friday afternoon, I tell you that. All right. Senate Bill 121.
Senate Bill 121 extends by 2 years the termination date and reporting requirements of Chapters 624 and 625 of 2024, which authorize Montgomery and Prince George's counties to use noise abatement monitoring systems.
I see a motion for favorable as a Montgomery Countyan.
Second.
Prince Georgian, on board? Yes, sir. All right. Is the motion for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? All right. Excellent.
Are you going to have, what?
That's a 20, that's a G5, right? G5. All right. All right, Senate Bill 125. That's
125 prohibits a governing body of a county or municipality from enforcing local laws or ordinance that, 1, establish a threshold of request to summon law enforcement or emergency services to residential property as grounds for designating the property as a nuisance, or 2, otherwise penalize or authorize a penalty against an operator, owner, occupant, or tenant for the act of summoning law enforcement or emergency services to residential property. And this is closing a loophole that was created by Chapters 768 and 769 that the General Assembly passed in 2023 that just prohibited the county or municipality from enacting those laws, but they didn't cover the enforcing whatever is currently on the books.
okay with this. Second, motion has been made for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? Awesome. Okay, great. Senate Bill 125 passes unanimously. All right, now we're on to Senate Bill 144. I know there are a number of amendments and forthcoming amendments, but also fiscal concerns. So we are going to hold that for additional work. It'll be back on the list next time. Go ahead, Josh.
So I think in your voting packet, there is a letter from the business law section of the bar detailing some of their concerns about the bill. So just for your information.
All right, well, now we'll move on to Senate Bill 160.
This bill requires a wholesale buyer or seller to provide certain disclosures in a contract of sale for residential property and authorizes the rescission of a contract and requires the refund of a deposit under certain circumstances related to the required disclosures. This bill does not apply to sales under Maryland Rule 14215 regarding foreclosures, and it only applies prospectively from October 1st, 2025 forward. There are amendments that you should have, both the amendment and interlineated copy from the Maryland Bar Association. They just make minor technical changes to make sure the terminology in the bill is applicable to the actual conduct that's happening.
Is the sponsor of the bill copacetic with the amendments? All right, excellent. So can we move the amendments? Is everyone okay with adopting the amendments? All right, now the bill's before you as amended. Further discussion? Motions? Motion's been made for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 160 passes unanimously with one amendment. We're going to hold Senate Bill 207, and because a couple of members have keen interest on working on it, and then we're going to go to Senate Bill 202.
Senate Bill 202, this is a departmental bill from the Department of State Police. It alters the circumstances in which DNA must be collected and stored in the statewide DNA database system within the Department of State Police's crime laboratory. It alters the individuals required to collect DNA samples and the process of collection, clarifies when DNA samples may be tested, placed in the statewide database system, or destroyed and expunged. The bill also requires the releasing entity, before releasing an individual from custody, to ensure that the individual's required DNA sample has been collected in accordance with state law. Additionally, the bill prohibits an individual from refusing to provide a DNA sample that is required, discharges an employee from the duty to collect a DNA sample when the individual refuses to submit, and establishes penalties for violations of the prohibition against refusal. Also today, we have Ms. Kelly from the State Police on hand for questions.
Let's start easy and then get to the more difficult. So the easy is the penalty piece. So right now it is a $10,000 misdemeanor to refuse the swab test. I just put that out there. What do you all, thoughts from the committee? Senator Love.
Thank you, Mr. Chair. I think I'm concerned with that penalty. And I understand that there needs to be some type of penalty. There is a consequence for refusing to take a breath test when you're pulled over and you're suspected of DUI. But I think misdemeanor and $10,000 is too much. I would be comfortable with a lower fine, a $1,000, $1,500, something like that.
No, I couldn't agree with you more. I think 10,000 is excessive. But so I'm much more comfortable with 1,500 or 1,000. But what is the committee? What's the will of the committee? 1,000? 1,000? I think so. All right. So make it 1,000. So the motion is to fine not exceeding $1,000 instead of $10,000. It's on page 6, line 3.
Correct.
That's all right. Okay. Is everyone okay? Do you want to read that into the record? I guess. I guess that's fine.
So,
good.
Oh, and just for Sandy for amendment tracking, but Mr. Chair, I think you got it right there. It's page 6, line 3. Strike 10,000 and replace with 1,000.
Thank you.
Okay. Is that okay adopting the amendment? Okay. So then the second issue, I think, kind of climbing back up through difficulty, is just the storage of the DNA. And Jamie, maybe you could help us with this. So like, if there's a matter, and then please come up. If you want to come up, if you want. It's up to you. Let's say there are different scenarios and different dispositions. So if a matter is, if there's a PBJ, or if a matter is steaded, how long under the bill would the sample be required to be held?
So, and I'll defer to Ms. Kelly if there's any disagreement, but my understanding of this is that while a person who receives a stat or a probation before judgment can apply for the expungement of their criminal record after 3 years, the bill and the existing law provides that those DNA samples are not expunged or not destroyed. Now, in conversations with Department of State Police, it was indicated that in theory, I don't know if in practice this has happened, but a judge could order that an expungement of a person's criminal record also include an expungement of those things. That seems a little bit grayer to me because state law does explicitly say that they are not expungible under this section of law.
So if you're talking about an untested sample, so if you're talking about any sample, and I checked, this is my AG, I'm speaking through his voice. If a person receives a PBJ, there is an assumption of guilt. But the conviction isn't complete because there's no sentencing. So I'm speaking to a group of lawyers, again, speaking through my AG. But usually the judge will say that you're getting a PBJ and you are to be a law-abiding citizen and not do this again, not have another infraction. If you do, this will come back. This can come back. So if the sample is then taken out of the system and expunged, and the person who has received the PBJ does a second offense, the sample needs to stay in the system.
No, I think we understand. Yeah, I think that's good. I mean, that's. I think we're all comfortable with that
Okay.
because obviously the final disposition is held in abeyance until whatever terms or conditions are met by the person. But what happens after there is successful PBJ and then you wait your 3 years to? Is it 3 years? 3 years?
3 years after.
So
3 years after successful PBJ, and then you go to move to get that PBJ expunged.
And the court can order that the DNA sample and the information that's in the database be removed as well.
Is that an
But that's not an
ambiguity or is that-
automatic.
I guess, respectfully, and I'd be happy to be wrong on it too. Just looking at the law on it, I do kind of disagree only because if I'm looking at bill page 6, beginning at line 31, which is section 2511 in the existing law, provides that a DNA sample or DNA record may not be destroyed or expunged automatically from the statewide DNA database if a criminal action is put on the stat docket or the individual receives probation before judgment. There could be some ambiguity there just because of the word automatically. I guess I just hedge a little bit.
Could you clarify that by saying like?
Our AG did bring up the fact that the word automatic is there, that it takes an action for the expungement to occur and a judicial action for the completion of that to occur. And sir, with all due respect, sir, the types of violations that we're talking about, we're not talking about a speeding ticket. We're talking about violent crimes. So the likelihood of PBJs are relatively limited for these types of cases. But be that as may, just it was part of the conversation.
No, but if a
with our
PBJ is
AG.
given, you're right. I mean, that fits your line of argument. But if a PBJ is given, then a judge has said, hey, I'm giving you some flexibility because the nature of your offense is not so egregious, potentially. Senator Love.
Mr. Chair, can we put in language that ties it to the expungement? So if it's expunged, then this DNA sample goes.
So, again, in theory,
You could add clarifying language if the committee, felt that that there was ambiguity. The committee could add language saying that section may not be interpreted to limit a judicial officer or a judge's authority during an expungement under the expungement subtitle. So if records are expunged, that, you know, they could also, they would be part of that expungement under the expungement subtitle.
We may be, it just says not automatically, but it doesn't say
Right.
that it may not be expunged.
Right.
So,
Yeah, I'm looking at it a little bit closer.
Yeah, yeah. Maybe
I'm hedging a little bit.
I think it's fine.
Yeah.
I guess the last policy call that we discussed is on page 5, lines 4 through 12 to start. Is any, just, it's a policy call, just read it, see if you have any consternation, and we can discuss.
Sorry, in which, so page 5 would provide the, I guess beginning on page 4, so subsection D, a DNA sample collected from an individual charged with a crime under subsection A3 of this section may not be tested or placed in the statewide DNA database system until any of these four occur. 1, a determination is made that probable cause exists for a qualifying crime in accordance with the Maryland rules. 2, the individual has been arrested for a qualifying charge in accordance with an arrest warrant. 3, an information is filed by a state's attorney for a qualifying crime in accordance with 4102 of the Criminal Procedure Article. Or 4, an indictment is returned by a grand jury charging the individual with a qualifying crime. So in most of those situations, those are tied to some individual making a determination that there was probable cause that the individual committed the crime, would be the triggering mechanism for actually testing and placing the DNA information in the database. So they would collect it at the time of arrest, but they would not actually conduct the testing until it got to one of these 4 points. I think just to sort of pick up on the feeling of the questions that I've gotten about it, in some but not all of those situations, it's a probable cause determination made by a judge. In others, it could be a commissioner making probable cause determination that there was probable cause to arrest the defendant. Could be a state's attorney because the state's attorney determined that there was probable cause to bring that information charging the crime. And then finally, it could be a grand jury finding that there's probable cause to bring that true bill for indictment.
Collection vote.
Thank you, Mr. Chair. I'm trying to understand the difference between the existing law and what effect the statute would have. it looks like, I know there was some discussion about whether arraignment was the appropriate term, and then if we don't use arraignment, trying to capture what that appropriate trigger point is for the DNA to be able to be tested. But it sounds like if we're comparing the existing law to the language we have, we're not just finding a new term for arraignment, but we're including a much more broad trigger point for the DNA to be tested. If we're talking about a probable cause determination, that's very broad. Whereas it sounds like 1 and 2 are very broad in this section, but then 3 and 4 seem more like the traditional arraignment. It's that opportunity for the state's attorney's information or for the grand jury indictment. Was there any kind of rationale provided by the department on why we wanted to open it up so broad to a probable cause determination? Okay. Thank you.
Actually, the language that is in the bill was discussed with the Attorney General's office as well as the court system, because there was a bill in before this bill is in this posture that did not adhere to the Maryland rules. It had language that the courts thought would create more hearings. So the language that you have before you is in consultation with the Attorney General's office and the court system to be the fairest, to be able to work within the system that is in Maryland that doesn't have arraignments per se.
I appreciate the explanation. I'll just be perfectly transparent. 1 and 2 are reasons why I could not support this bill. But when it comes to 3 and 4, I think that is more in alignment with the existing law, but 1 and 2 open the door so broadly and so wide. Those probable cause determinations are made by a variety of actors in the criminal legal system, and I think that that bar is just too low. Thank you, Mr. Chair.
As I understand this, and I do have a question to follow up, the probable cause in all 4, there's no difference, right? I mean, probable cause has meaning, been interpreted by courts, so unless you tell me, am I wrong about that? Is there a probable cause that's the qualitatively, substantively different between 1 and 4? And then I have another question because I'm not familiar with criminal law.
Probable causes, and courts have opined on this. It's not a specific technical term. It isn't easily reduced to sort of calculus. It is generally a low burden, but you're correct. Just to reduce it, it's that it's fact sufficient that a person of reasonable caution is warranted in the belief that a crime probably occurred, or that person probably committed the crime.
Now, where I'm really lost in the weeds is, I don't know in 1 who's making that, there's this a determination, you know, I don't know who's making that determination. But what I don't understand is, let's say you don't do 1 or 2. Eventually, do you get to 3 or 4? In other words, if it's not 1, a determination made that there's probable cause exists. Okay, an individual has been arrested. So if we don't do 1 or 2, will eventually anybody coming in contact with the criminal system that isn't released or otherwise go through either an information, in other words, the person's been arrested, and that's not the trigger. Will eventually an information or indictment have to be returned? So eventually one of the 3 or 4, one of the triggering events will come into play?
Right. I was actually thinking about that question as this colloquy was going on too. And I've got to admit, the only situation that I can think of, and I'm not even sure it would be really applicable, well, 2 situations, but one I'm less certain of than the other. You know, we have charged by citation. A lot of these are felonies or crimes of violence, or we've also got burglary. Maybe, Ms. Kelly, I don't know if you have the answer, but I'll just kind of give my take on it. And just with the condition that I can look into that further for you, Senator.
For sure,
but
get back.
maybe a charge by citation, but also maybe a commissioner complaint where somebody actually brings, makes out the complaint to a commissioner, and then the commissioner issues the warrant. I'd have to double check on whether that ends up being charged by an information later if the state's attorney decides to proceed with that commissioner complaint case. But I'd have to get back to you on that, Senator.
And what is your understanding, and we can certainly ask Ms. Kelly, but for one, which is, I mean, I get that, two, there's going to be an arrest, you know, a warrant's going to be issued, an arrest warrant, right? And that usually comes through a court, doesn't it?
Could be a court, could be a commissioner.
Or commissioner, right. But there's an official process. It's not the cop, it's not the law enforcement officer. He is not the person who's doing it. It's a commissioner or a court.
Right.
All right, so that's two. But on one, what is your understanding of who's made this determination under one? Who's looked at that? And then maybe they know what they're thinking. It's a catch-all, but I don't know what it's catching.
I think one, so I can speak to, you know, my interpretation of reading one. Ms. Kelly may be in a better position to speak to their intent with the language in one. But my reading of one is that, you know, we're talking about the Maryland court rules here, so it is a probable cause determination either being made by a commissioner or by a judge. Obviously, police officers make a determination when they arrest somebody warrantlessly as to whether or not there's probable cause, but I don't really, because there's the reference to the Maryland rules, I'm not reading an officer's determination of probable cause as being what's meant there. But again, I kind of defer to the department as to intent, and
That's
obviously.
very helpful. And what does the department, if you don't mind me asking the department what they mean? Yeah, so Ms. Kelly, what were you thinking? What is the department thinking for number one? I mean, does it involve a law enforcement officer on the street, or does it also require, you know, a court or commissioner or something else?
The intent is that the commissioner is making a determination. A law enforcement officer would never make a determination as to whether or not that's a first appearance. You know, you arrest somebody. There's a aggravated party who is, I mean, abduction, arson, kidnapping, manslaughter, murder. Maybe the victim can't complain, but somebody has said that so-and-so is suspected to be the person who's committed the murder. A police officer would go investigate, take the person into custody. They would go before their first appearance for a district court commissioner. And at that point, the commissioner would establish whether probable cause for any furtherance of the charge would go.
So in all of these, 1 through 4, I know they're phrased differently because there are different ways you end up, you know, using probable cause to capture a potential defendant. But is it true that between 1, 2, 3, and 4, a court or commissioner will be always making a decision or be part of the decision, or I guess not with a grand jury, and maybe not 3 and 4. Is that how it works? 1 and 2 require a court or commissioner. 3 and 4 require state's attorney or grand jury. Is that how this works?
1 and 2 are officers of the court are making those determinations. It would never be a law enforcement officer.
I heard that 1 and 2 are officers of the court, yeah. And what's 3 and 4? What'd you say?
That's a process that's past the law enforcement. That's when the state's attorney.
Well, I can't hear you, but hopefully I'll get a tape of this because I can't hear you.
3 and 4 are actions that are taken by courts or the state's attorney, so law enforcement at that point is not the driving factor. Sorry, I'm a little under the weather.
I can't hear you or see.
I'm sorry.
If it's the department's intent that a judicial officer is going to be making, even for 1 and 2, with 2 we determine that, and 3 and 4 you just determined that on the record. That's the intent. For 1, your intent you said, but it's not maybe as clear, but Jamie, do you have language that could potentially make that clear? And if we do make it clear, Senator Henson, would that assuage your concerns?
It would. I want to be clear about the standard that's there and that we have someone who's qualified, trained in making that decision.
100%.
So I would insert in line 4, it would change number 1 to read, a determination is made by a judge or district court commissioner that probable cause exists for a qualifying crime in accordance with the Maryland rules. Uh-huh.
That meets our intent.
Is it okay adopting that amendment? Yes, please, yeah, absolutely.
Unless I'm reading it wrong, that's still a lowering or lessening of the standard. If the standard at first was you couldn't do it prior to the first arraignment, we're talking about going in to court and having a judge, having, that state's attorney bringing that information in and having the charge formally arraigned. If we are now including a commissioner in there, and then you bring up the very valid point of civilian complaints, you could have no officer investigate. Someone comes in, makes a civilian complaint, commissioner then makes the determination. In my opinion, that is lowering the standard substantially, and I think I would caution against that, and I know that would impact my vote on the bill.
Yeah, I kind of want to bifurcate what you're saying, because I agree with you 100%. Commissioners make determinations of people's liberty all the time, so I have no problem if they're involved in this, because they're already making a determination whether someone stays in jail or not. But on a swearing out by a private complainant, I agree that when we had an incident in Montgomery County where someone just made something up, the commissioner went along with it, and suddenly that person had, sheriffs knocking at their door. So I agree that we have to exclude the private complaints.
That'd be fine. We're good with that.
Okay, so I mean, to draft out the private complaints, I think that we're going to, being advised, it's going to take a little bit more than just wordsmithing it here on the fly. So we're going to have to hold the bill, but I think that the committee is ready to move on this after a few concerns, which are in alignment with the department's goals. So
Certainly.
I think this is a good thing, and shows that we're taking the bill seriously.
Are we adopting this amendment?
We did, yeah. Okay, so that we're going to hold that. It'll be back on the next voting session. But I think this has been great. I know this is a process, but this is a really. I know we only voted like 5 bills or something, but this is a really good voting session. I want to thank you all for being engaged and locked in, especially at the end of a long week. This is exactly how this committee should function, and we have risen to the importance of the work that we're doing. So I really appreciate you all doing this. That concludes our work for the week. We'll see you all on Monday. Oh, yeah, can we, yeah, we